to report the injury when it happened, yet he chose not to follow that. Furthermore, at the first hearing, he testified that he had no prior low back treatment when it was obvious from review of the medical records that he had been treating up until the date, almost a week before the injury occurred. Judge Cigna is likely to find that his entire testimony was not credible and to deny the claim petition outright. We do acknowledge that he's unlikely to ever be able to return to his pre-injury job, and therefore we're willing to negotiate. If we can get him to resign and get on with our business, we'd be willing to do so here.
Okay, I see some pros and cons with each side of the case as it's been presented so far. I've been a judge for a long time, Mr. Lafferty, and based on my review of the file, I think you should be prepared to settle this case. You know, I mentioned some back benefits that are payable, assuming Judge Cigna renders a favorable decision. Mr. Cash, you run the risk here of a negative decision. So I think it might be in the best of all parties concerned to try to resolve this. Ms. Bailey?
Thank you, Your Honor. And Your Honor was right. Mr. Cash's compensation rate is $845. That's the maximum benefit for an injury that happened in 2010. We think it is likely that the judge is going to find in our favor, as Mr. Cash presented credibly during his testimony. Therefore, in that regard, we are prepared to make a demand of $175,700, which is approximately 4 years of workers' compensation benefits. Plus, we are demanding that the employer and its insurance company waive the sickness and accident credit and pay any out-of-pocket or outstanding medical expenses related to his injury and pay the health insurance lien.
I tend to think that that's not a bad demand coming for a first demand from the claimant's counsel. I find a lot of credible issues in what I've read up to this point, but keep in mind, I'm not the one making the decision on this, but I do see where the claimant gave proper notice within 120 days. He filed his claim timely within 3 years of the date of injury. So I don't see those as being issues. There are some mitigating factors, though, however, with the medical. I'll concede that to defense. But I think there's a lot to argue there. So with that said, Mr. Lafferty, how do you feel about claimant's opening demand?
Well, I obviously think it's way too high. I understand that it's been 2 years since the injury happened and there's some potential back benefits that are accruing, but he's been receiving S&A benefits the entire time. We're only going to have to pay a fraction of those back benefits, the difference between the S&A and the compensation rate. We're certainly not going to waive our credit to that here or elsewhere. Furthermore, my clients they're not inclined to provide Mr. Cash with a windfall. These numbers that we're talking about here, he's going to end up making more money for being injured than he was going to make if he had continued working that entire time. In light of that, I'm prepared to offer $43,940, which is the equivalent of 1 year of benefits, which is more than he would receive even if he were to prevail in the claim petition.
May I, Your Honor?
Sure.
That's just absurd. A windfall to the claimant. His average weekly wage is $1,300 a week. He is, under comp, only entitled to $845 a week. There is no windfall to be had by Mr. Cash for getting injured. Once we win the claim petition, your client will have to pay Mr. Cash $845 a week until you decide you think that you can do something else.
Well, once you win the claim petition, we'll make a light duty job available as soon as we get that petition, or we'll send him for a labor market survey, or we'll fund employment down at the Goodwill. We won't be paying any benefits past the date of that decision. I can guarantee you that.
I can't work light duty.
Yeah, and that's another thing. You may think that you can make work available for him, but right now he has not been released to any type of work. Therefore, your client is on the hook for $845 a week. And should down the line he be released to some type of work, because there's no evidence that he's going back to his regular job, a labor market survey with an average weekly wage of $1,300 isn't going to significantly reduce your client's liability at all. Therefore, that said, we can reduce to $163,000 to resolve this case, but that's it.
All right, Mr. Lafferty, you heard the reduction of $163,000, which I think, given this situation, seems pretty fair. If you're not prepared to pay any more to resolve this case, and it doesn't appear that you're willing to do that, I would suggest that this go back to Judge Signa to render a decision.
I agree with that, Judge. Based on the conversation I had with my client earlier this week, we're never going to get in the same ballpark here.
Well, I think you should have another discussion with them, but for the time being, we'll adjourn this and put it back in front of Judge Signa. Thanks for attending.
Thank you,
Thank
Judge.
you.
All right. Justine, we have to talk.
All right, Johnny.
I assume you got a copy of that return to work letter in the mail that Pennsylvania Tube sent me, based upon Dr. Black the quack finding me fully recovered after a 5-minute exam. 5 minutes is all it took, Justine.
I know.
And I'll tell you what, they say I could go back to work full duty, but I can't go back to work. I've got constant pain. I'm on Social Security disability. And there's just no way that I can go back to work. And the most ridiculous part of this is that they fired me. They've already fired me once.
Well, you won your grievance, Johnny, so that's good. I know they fired you because of that surveillance video. That was ridiculous, but you won your grievance, so you're no longer fired. So you still have your job.
Yeah, but I can't go back to work.
I know. And, you know, the reason why they sent you this letter is because Dr. Black said that based on her 5-minute examination that you're fully recovered from your work injury and that you can do your regular job. So that's why they sent you this. Now, Dr. Wright is still in your corner. He says that you can't return to work to your regular job yet. So what I'll do is I'm going to do a letter to your employer stating that Dr. Wright has not released you back to your regular job yet. Here are your restrictions. I'll give them a copy of Dr. Wright's restrictions. And well, I'll also copy the insurance company on that, and I'll send that to the employer in response to this letter for you.
Yeah, but my concern is whose restrictions control? Is it going to be Dr. Black, the dirty hack, or Dr. Wright?
You know what? That's a good question, Johnny. And you know what the workers' compensation law is that you are required to make a good faith effort to return to work within your restrictions. Now, whether or not you try this job is up to you.
I'm not going to.
And, you know, I didn't think so, but we have to have this conversation. You know, your doctor has you on restrictions, so that's the defense that we are going to use in response to Dr. Black's ridiculous opinions. However, and I got to tell you that because your employer is asking you to return to work, even though they're using Dr. Black and not your doctor, if once you don't show up for work, they can fire you. However, they would have to continue to pay you your wage loss benefits until they get a judge to say otherwise.
They have to continue to pay me something after all we went through. And how's this going to get in front of a judge? I thought we were done with all going in front of the judge.
Unfortunately, once you're on workers' compensation, you're never really done with the judge, as petitions can be filed at any time. Once you don't show up for work, they will no doubt that day or the next day file a petition to either terminate or suspend your workers' compensation benefits.
Terminate and suspend? What does terminate and suspend mean?
Well, first, don't worry, they just can't stop paying you benefits.
I hope not.
No, the judge has to order that to be done. And what happens is once you don't show up for work, they're going to file this suspension termination petition. You okay?
I'm all right. I'm still in pain, and that's what just really drives me nuts about this.
I know. In the termination or suspend, they're going to ask the judge to completely stop your workers' compensation benefits, both your wage loss and your medical, because their opinion is, oh, he's fully recovered from his work injury. And if that don't work, their alternative is a suspension petition. Well, even if he's not fully recovered, we shouldn't have to pay him any more wage loss because he can at least do this job, and he didn't even try to do it. Now, of course, we're going to defend that petition, and we're going to use Dr. Wright to help us do that, because his opinion is you're not fully recovered, and you can't return to your regular job.
That is his opinion. But I'll tell you what, Justine, I got this letter, it really upset me, and I'm getting tired of doing this. I'm getting tired of Mr. Lafferty and his questions after questions, and I'm getting tired of Dr. Black, the Sawbones. Is there any chance we could settle this?
You know, considering the Workers' Compensation Act, it may be a good idea to resolve your case. Especially since once you're on comp, you know, they can try various tactics to try to get you off work or off comp, and the suspension termination is one of them. What will happen is once you don't show up for work, like I said, they'll file that petition. We'll have another hearing, and then after that hearing, we'll have another mediation. And at that time, we can resolve this work injury and any other workers' compensation claims that you have on. Now, I can't see around the collar of your shirt, but have you incurred any scars because of anything that happened at work from your collarbone up?
On this beautiful face? No.
No?
No, I don't have any scars.
No, you're good there. Okay. What about any hearing loss?
What?
Hearing loss. Do you have any hearing loss?
Hearing?
Hearing loss.
Oh, yeah. My wife says I do, but I think that's selective hearing loss. I just don't like some of the things she has to say. I also have, but I do have trouble hearing sometimes in crowds, like at church and things like that.
Okay.
Speaking of which, I brought this with me here, and this also deals with settlement. This is something they sent me in the mail from the insurance carrier for Pennsylvania Tube, and it says here, what I see anyways, is they're going to pay me a lump sum of money in exchange for my hearing loss. No need to go to any hearing, no need to go before any judge, no Mr. Lafferty, no Dr. Black. It's real easy and simple.
Well, first, it's improper to settle any workers' compensation claim without a judge approving it. And you've been on Social Security disability for over 24 months, so you're Medicare eligible. You're getting Medicare benefits. Medicare has to approve any settlement or you can lose your Medicare benefits. So you got to be careful. And I'm reading this, and this is a release for any and all injuries and claims you have against Pennsylvania Tube. So if you sign this, they're trying to have you sign off on any and all injuries you suffered at work, including your back injury.
No, I'm not signing off on it. I didn't see that in there.
Now, are you looking to take your disability pension anytime soon?
Yeah, I am, and I tell you what, I'm hoping that settlement's not going to impact my disability pension.
Well, first, I want to tell you, do not retire while on comp because it can only negatively affect your benefits.
Okay.
And we have to be careful of any language of any settlement because the wrong language could negatively affect your future benefit or your future pension benefits. Like in your case, the language of this indicates that if you get a lump sum for specific loss, which is what hearing loss is, your pension is completely offset, which means you don't get your pension right away once you're approved for it.
That thing isn't worth the paper it's written on, that's what you're telling me.
Yeah. Do you want to go back to Pennsylvania Tube at all?
No, I don't. In the past I probably would have said yes, but I've been thinking about that a lot lately. It's bad working conditions there. It really is. I mean, we work around dangerous machines and we work around dangerous chemicals and other God knows what. You know, I have friends that have worked there, have breathing trouble. And I know of one guy that was diagnosed with cancer. I guess it was leukemia, I think, from benzene exposure is what I heard anyways. And that's the type of things that come with working in a place like that. And it seems to be getting worse rather than better. And I myself have some trouble with my breathing from time to time.
You know, that's quite possible. You know, we are very familiar with that plant and have had several people there with toxic exposure. So down the road, if you or any of your colleagues are diagnosed with an occupational disease like leukemia, cancer, mesothelioma, you would have a cause of action against the manufacturers and suppliers of the products and the chemicals that cause your illness. And that would be an option, you know, down the road once you're diagnosed with a condition, you know, after your workers' compensation case.
Let's hope that doesn't happen. I think I have enough going on right now.
Yeah, I hope it not. I hope it doesn't happen for you. But if you're having problems breathing, you may want to get it checked out.
Well, I'll get around to that.
Okay.
I see enough doctors as it is already.
I know. Well, I know you're not going to return to work, so once they file the petition, we'll defend it, and you know, we'll keep you updated on the progress. We'll have another hearing, and then we're going to try to resolve your case, okay?
Back to court. All right.
All right. Thanks
All
for
right,
coming in,
thank you
Johnny.
very much.
You're welcome.
I'll call the case of Jonathan Cash versus Pennsylvania Tube. We're here today on a termination and suspension petition. It's defendant's burden. Attorney Lafferty, do you have any exhibits?
Yes, Judge. I have first a narrative report authored by Dr. Black, 17 pages long, in which she indicates that even assuming that the claimant sustained the injury that was found in the decision on the claim petition, that he's fully recovered and there are no ongoing objective evidence of any problems in his low back or right leg.
And any other exhibits?
Yes, I also have a return to work letter sent by my client to Mr. Cash. And finally, I have a surveillance DVD taken by a private investigator documenting Mr. Cash.
Thank you. I'll mark these as exhibits. Any objections?
Hearsay objection to every exhibit, Your Honor.
We will admit these for supersedis purposes, and they will not be admitted for the case in chief until such time as depositions are taken.
Thank you, Your Honor.
Attorney Bailey, do you have any exhibits?
I do, Your Honor. I have a report from Dr. Wright, Mr. Cash's treating physician. It is his opinion, as his treating physician, that Mr. Cash is not fully recovered from his work injury, and he's still restricted in his capabilities as a result and is unable to return to his regular job.
Attorney Lafferty, any objections?
Hearsay, Your Honor.
This will also be admitted for supersedis purposes, but not for the case in chief until depositions are taken. Do we have testimony today?
Yes, Your Honor. I'd like to present the testimony of Mr. Cash.
Okay. Mr. Cash, raise your right hand. You understand that you need to tell the truth, the whole truth, and nothing but the truth.
I do.
You may proceed.
Can you state your full name again for the record?
Still Johnny Cash.
Okay, Johnny. Did you sustain a low back injury at work on October 15, 2010?
Confirmatory.
Mr. Cash, do you remember testifying the last hearing?
I sure do. I remember that.
Okay. And so it was in front of Judge Stigna as well, so we're not going to repeat that testimony. So I'm going to start where we left off the last time. Is that all right?
It's all right with me.
Okay. Since then, have you continued to treat for your injury?
I have. I've continued to treat with Dr. Wright.
And what type of treatment has Dr. Wright provided to you since you last testified?
Well, he's done some injections, spinal cord injections. They really haven't done too much of anything, unfortunately. Now he's talking about implanting some kind of stimulator, spinal cord stimulator of some sort.
Are you on any medication for your injury?
Just Percocet and Flexeril, that's it.
Johnny, are you okay?
I'm fine, I'll be all right.
And the judge indicated before, if you need to stand up, just let us know and you're free to do that, okay?
Like I've indicated before, I need to lay down.
You continue to suffer symptoms as a result of your injury?
Oh yeah, I do. You know, the back pain's less than it was. I mean, my lower back's better. But my right leg, I still have constant pain going down that. It's pretty bad. And I don't know that I'll ever go away.
Has your doctor released you to your regular job?
No, Dr. Wright hasn't released me to return to work at my regular job. He has me on 25-pound lifting restrictions. I'm not allowed to repetitively bend, push, pull. Like I said, no lifting over 25 pounds.
Okay. Mr. Cash, do you believe you're fully recovered from your work injury?
No. I'm still a hot mess, I'll tell you that. I have this constant pain down my right leg. Anytime I try to lift something over, say, a gallon worth of milk, I lose my balance. I can't walk on uneven surfaces very well either. So no, I don't consider myself fully recovered.
If your doctor would release you to a specific job, would you at least try it?
Yeah, I'd love to go back to work.
Mr. Cash, those are all the questions I have for you. Mr. Lafferty is sure to ask you some, though.
Sure witness, Mr. Lafferty.
Mr. Cash, do you